Hi, everyone. My name is Cliff Kirsch, and I'd like to welcome you to the Eversheds Sutherland webcast, the SEC's proposed fiduciary duty and standards of conduct for broker-dealers and investment advisors. I'm joined today by my colleagues, Eversheds Sutherland partners Michael Koffler, Carol McLarnon, and John Walsh. Before we begin, a few housekeeping notes. First, if you'd like to receive CLE credit for this webcast, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submissions. Also, if you have any questions during the webcast, please submit them via the Ask a Question text box on your viewing console. If you'd like to request a copy of the slide deck, you could please contact any one of us, me, Michael, Carol, or John, and we'd be happy to get you a copy of the deck. The SEC's proposed a comprehensive standard of conduct rules, forms, and interpretations which would require registered advisors and broker-dealers to provide a relationship summary to retail investors. It establishes a standard of conduct for broker-dealers when making a recommendation of securities transactions or investment strategy to a retail customer. And it also provides an interpretation regarding the fiduciary standard of conduct for advisors. So in this hour, we hope to help you analyze and think about the new requirements. We hope to draw out how a broker-dealer standard of conduct differs from an advisor's fiduciary obligations. We hope to start talking about and have you start thinking about some of the operational issues that will arise, and what will advisors need to do to satisfy the fiduciary standard of conduct. So a lot to cover in the hour, and again, feel free to raise questions. And as we begin the discussion, just to lay out a couple of slides of a foundation of the framework, what just happened. And just a couple of weeks ago, on April 18th, in a 4-to-1 vote, the SEC proposed, again, they haven't adopted anything at this point, they proposed a comprehensive set of reforms governing the fiduciary duty and standard of conduct applicable to broker-dealers and advisors that provide retail investment advice. And again, our focus is, and the SEC's focus is on the retail marketplace, not the institutional marketplace. The proposed rules would require BDs and advisors to summarize their relationship to retail investors, establish a best interest standard of conduct that would apply to broker-dealers, restrict the use of the term advisor or advisor, ER or OR, by broker-dealers, and require advisors to adhere to certain conduct as fiduciaries. And the way that the proposal does that is in 3 parts. And think of the reform package as being made up of 3 parts. One is a new broker-dealer standard of conduct, and you'll hear reference today to regulation best interest. That's the new broker-dealer standard of conduct. You'll also hear reference to the Form CRS. That's a new disclosure document that would apply to both broker-dealers, advisors, and dual registrants, entities that are registered both as broker-dealers and advisors. And we'll talk about that. And also a new commission interpretation, not a rule, but an interpretation regarding the standard of conduct for an investment advisor. And in the same release, the SEC requests comments on enhancing certain regulations that apply to advisors. And on the next slide, just to sort of drive it home, what does all this mean? And you break it up into broker-dealers and advisors. And in short, the reform package would establish a new framework governing investment professionals who provide advice in the retail marketplace. For broker-dealers, it would mean a new standard of conduct, which is going to be regulation best interest. It would mean new disclosures. It would mean new restrictions on titling. For advisors, it would be a new fiduciary interpretation, new disclosures, and possible new regulations, which we'll get to. And throughout, there are special considerations for dual registrants, and a real focus on this in terms of dealing with entities that are both broker-dealers and advisors, and defining the responsibility of those dual registrants when they're either acting as a broker-dealer or an advisor. So we'll talk about that. At a high level, what the SEC proposal seeks to advance, what it's designed to advance, is to allow choice. And the SEC has really been up front at the meeting, in the release, and in public statements since, that one of the goals is to preserve the commission-based model, not to favor one model over the other. The other thing that the SEC has said that these reforms are meant to do is raise the standard of conduct for broker-dealers, but not impose the same standard that applies to advisors. So again, the SEC opted not for a uniformity, but again to enhance the standard of conduct for broker-dealers. And throughout the reform package, it's a goal of addressing investor confusion. So again, those are the goals, and this is how the SEC package tries to get to those goals. And on the next slide, we just wanted to spend a couple of minutes talking about what got us here, what led us to the 2018 proposal. And as good a starting place as any is probably the Tully report back in 1995, and this chronology really drives home that we've been dealing with this issue for decades, and what led us here, number one, is broker-dealer conflicts of interest. And the Tully report in 1995 basically urged consideration of broker-dealers considering instances where a fee-based account might be a preference for investors as opposed to commission-based accounts. And again, it asked broker-dealers to consider the use and encourage the use of fee-based accounts where it made sense, where it was appropriate for investors. And at the same time, the SEC issued a number of no-action letters which permitted registered reps at broker-dealers to use certain designations that had advisor-like characteristics and without registering as an advisor. So what we saw here in the 1990s was broker-dealers entering advisor territory. We saw it by, again, fee-based accounts, the use of certain titles which suggested advisories, suggested that they were advisors. And remember, at the same time, broker-dealers were already operating with the elimination of fixed commissions, all forces that led them to advisory activity. And broker-dealers said, I like it here, I like it in this space. And it caused the SEC to adopt a rule to try to demarcate when a broker-dealer was within the lines of the broker-dealer exclusion, or when their activity, the manner in which they conducted that activity, caused them to register as an advisor. And that was back in 2005. The SEC adopted a rule allowing fee-based compensation, and again, in that rule, there was a whole framework as to when broker-dealers were able to avoid registering as an advisor. That rule was vacated in 2007, and then in 2010, with the Dodd-Frank Act, what that basically suggested or signaled was an end to the SEC trying to demarcate when a broker-dealer could operate within the Advisors Act or not. And Dodd-Frank said, let's focus on the standard of conduct that applies to a broker-dealer when they provide retail advice. And specifically, let's give consideration to whether that standard of care should be uniform between broker-dealers and advisors. And that led the SEC in 2011 to release a study on the standards of conduct, which did recommend a uniform standard of conduct. That was a staff study. And although that staff study didn't necessarily correspond to a rule proposal, it helped inform the 2018 rule proposal. And again, for those who are newer to this area, it still remains a great resource, a great reference tool. So in 30 seconds, I'm going to turn it over to Carol to talk about some of the DOL words on this chronology, because again, the SEC is just sort of one end of sort of the developing of investment professional recommendations, and the DOL had a lot. So Carol, in maybe 30 seconds, I could turn it over to you. But we saw in after 2011, the SEC really wasn't able to advance anything, whether it was internal disputes, controversy, whatever the reason. There was nothing advanced until what we saw today, a few weeks ago, the rule proposal. And Carol, there's a number of points on the DOL. Could you walk us through those?
Sure. In 2010, the DOL decided to get involved in standards of conduct beyond what it had usually been regulated up to that point, and in 2010 proposed a new fiduciary rule for the first time for retirement accounts. That was unsuccessful, and in 2015 they reproposed the fiduciary rule along with a proposed exemption, the BIC exemption, that was very controversial. In 2016, the fiduciary rule, the final rule, was adopted with a very quick timeline to comply by the end of 2016. That was in anticipation of presidential election and possible administrative change. As we know, that is what happened, and in 2017, President Trump issued a memo to the DOL requesting further review of the fiduciary rule. During that time, the DOL also extended the transition period and the effective date for the fiduciary rule other than the expanded definition of fiduciary, which we'll talk about later. Just recently in 2018, the Fifth Circuit vacated the DOL rule in its entirety, and that's where we are right now with the DOL.
Great. Thanks, Carol. And on the next slide, take a look at the current regulatory landscape before sort of this proposal. What is the regulatory landscape? And, it's interesting because a lot of times press reports, will say things, that broker-dealers and advisors do the same things. They're, investors don't understand that there's a difference. These proposals, we have to keep in mind, are built on the differences, and there are differences, and we try to sort of capture those differences on this slide. A broker-dealer acts as a principal or an agent for an issuer in distributing and selling securities to the public. Their job is to sell securities to the public, and often they're part of the issuer distribution chain. They're receiving transaction-based compensation, and to avoid being an advisor, their advice has to be incidental and no special compensation. That's a part of the Advisors Act definition for which broker-dealers rely. And there's also a suitability requirement under FINRA rules to which broker-dealers are subject, and that comes into play a lot with regulation best interest because the suitability requirement helps inform regulation best interest. Advisors, on the other hand, provide advice about securities, and they act as an agent to their client in providing advice, and they're getting fee-based compensation. And they're also fiduciary to the clients, and that's via a Supreme Court case that's decades old, the capital gains case. So again, very, very different type of functions, and that's the landscape in which these proposed rules are built upon. Some of the issues that we were anticipating before the rule proposals would be: what is the role of conflict disclosure? What was the SEC going to say about reasonable compensation? What would be the duty that a broker-dealer owes to a customer? Would it be best interest? Would it be fiduciary duty? Would it be something else? And what about enforceability, private rights of action? All things now, because of the proposal, we have a better handle on that we'll chat about. And I'm going to, in 30 seconds, I'm going to turn it over to John to start talking about regulation best interest. But just, what the SEC was considering, or the options available, another way to say it, for the SEC in approaching the reforms, one option was to do nothing and leave broker-dealers subject to a suitability requirement and the current structure, advisors as fiduciary. Another option was to redraw the boundaries for the broker-dealer exclusion, and force broker-dealers to operate under the Advisors Act, in more restrictive circumstances. That was another option. Apply a uniform duty for advisors and broker-dealers, basically say broker-dealers are fiduciaries just like advisors, or tailor the duty that a broker-dealer owes to its clients. And I think it's fair to say that's where we ended up, a tailored duty for broker-dealers, and that's the best interest standard. And John, is it okay if I hand it over to you to walk us through that?
Sure, of course, Cliff, and thank you. Well, what did the SEC propose? As Cliff suggested, it proposed that when a broker-dealer makes recommendations to a retail customer, it has to act in the best interest of the customer. And I think this is a good place just to stop for a second. And speaking for myself, I think the SEC deserves a lot of credit for doing this. They have indicated that their goal is to take the existing regulatory structure and enhance it, to dial it up. It's a big project, as shown by the fact that the materials that they issued around the reform are more than 1,000, something like 1,000 pages long. It's a challenge, as we'll see as we work through it. And I'm confident by the time it's done, there are going to be some difficult discussions, perhaps even debates. But the goal of taking the existing regulatory regime and enhancing the best interests of customers within it should be everybody's objective. And with that in mind, let's turn to one of the first topics of discussion. And that is, while this is a best interest standard, the Commission does not propose to define what the best interest is. What is actually in that standard? Now, I'm sure you can imagine the debate that's going on. On the one hand, can you, in fact, articulate a standard which can encompass best interest as it applies to all retail customers? Tough drafting. On the other hand, can you ask a financial services firm to meet a standard that has not been defined? This is a point of discussion right now in the regulated community. Interestingly enough, it was a point of discussion at the Commission meeting, where commissioners commented on the fact that they have not defined the standard that they're seeking. The result has been something along the lines of what I would call fiduciary-like, a fiduciary-like approach without actually being fiduciary. And if you parse through the footnotes of the Commission's release, and of course, as we all know, in the regulatory world, all the good stuff is hidden in the footnotes, you will actually see a lot of discussion that takes fiduciary learning and applies it to the best interest standard without actually saying this is a fiduciary rule. Well, if the Commission is not going to tell you what best interest is, it will tell you how to get to it. And they said there are 3 obligations which you need to meet. And you can see them there on the slide: disclosure, care, and conflict of interest. Let's spend a few minutes on each. I think the disclosure requirement in regard to material conflicts of interest is probably the piece of the best interest rule that's getting the most attention because it's a requirement that is going to impose some difficult challenges on the regulated community. The SEC has said it wants short, plain English disclosures that should capture all material conflicts of interest, and it anticipates that it will measure the disclosures against a negligence standard. Now, we all know brevity is the soul of wit. On the other hand, if it's a negligence standard, if you're too brief and you leave something out that should have been included, well, then you can face liability for that. And so looking down the road to when this regulation is in effect, I am confident we will all see a lot of very careful drafting to try and meet the Commission standards of shortness and plainness, but at the same time not leaving out things that the Commission would want to see in there. What are some of the things that the Commission expects to be covered? Well, proprietary products, products of affiliates, if you only offer a limited range of products, how you make choices among share classes, whether or not you are an underwriter of the product you're recommending, rollovers or transfers among account types, allocations of investment opportunities. So I think just running through the issues that the Commission's looking for in this disclosure, we can see it's starting to grow. Also, there are a couple other questions before we move on to care. Number one, will the form CRS that Cliff mentioned, the Customer Relationship Summary, will that do the job? No. The answer is no. That's too high level. When the Commission is talking about the disclosure under the best interest standard, it's talking about different disclosure than the form CRS. Question two, when do you deliver this disclosure, the best interest disclosure? There really are a number of options here. You can do it when you establish the relationship. You can do it periodically. You can do it when you make the recommendation. The one time that it's not okay, the Commission says, would be after you've made the recommendation. And even there may be some leeway in terms of structuring notice to the client in details. Number three, do you need to repeat at every recommendation? Not necessarily. The Commission says if you've made the disclosure before the fact, before the recommendation, and nothing has changed. And then finally, what records must you keep? Well, the Commission is proposing a new record-keeping rule that says you have to keep all information collected from and provided to a retail customer. I'm going to predict that's going to come up a lot in the comments. If the goal is to capture the disclosure that's required under the best interest standard, it seems more all-encompassing than that. So I think this is something people are going to want to look at very carefully. Let's talk a bit about the rest of regulation best interest. There is also an obligation of care. In the obligation of care, the SEC said that it's introducing a relatively new concept, one that has not gotten a lot of attention in the federal securities laws, and that's the idea of prudence. To have an obligation of care under this regulation, it expects broker-dealers to act with prudence toward their customers. Now, Carol mentioned the DOL connection in all of this, and in fact, the SEC in its release pointed to the DOL rules when it talked about introducing this concept of prudence. What does prudence mean here in the obligation of care? One, you have to have a proper evaluation before you give a recommendation. In other words, you have to have a lot of due diligence. And then number two, you have to have a reasonable basis to believe the recommendation is in the customer's best interest. Cliff mentioned that suitability plays an important role in these rules. This is one of the places where it shows up. The SEC said this whole idea of the obligation of care is designed to take suitability and to build on it, to take what we all know of as suitability and to say, now we're going to take it to a new level. There are a couple areas where it comes up in particular. Alternative investments, justifying the cost of an investment, making sure that your prudence includes knowledge of the details of a customer's investment profile. And the Commission said that in exercising your obligation of care, disclosure alone will not be enough. And I think this is important to note because this is a big package of rules with a number of different things happening at the same time. And if some places disclosure is very important, in other places disclosure is not enough, the obligation of care is one of the places where disclosure will not necessarily suffice. And again, the SEC said proof of fraud will not be needed to show that someone fell short in their obligation of care. So we're again looking at a negligence standard. The final topic under the best interest standard, all on that one slide, is conflict of interest. And the SEC wants broker-dealers to adopt written policies and procedures to deal with their conflicts of interest. And here again, this is one of those areas where the SEC says, you know what, we want you to take your existing supervisory and compliance structures and ramp it up. It's not starting over again. It's saying, what can we do within the existing regulatory regime to enhance the best interests of customers? And this is one of those areas. And let's go, if we could, to the next slide. Thank you. And how must a broker-dealer address conflicts that create financial incentives. There are actually two categories of conflicts in the Commission's approach and its proposal. General conflicts, which we can probably describe as anything other than a financial incentive, and then conflicts arising from financial incentives. And in the latter category, the Commission has included anything pretty much that's compensation related, contests, special awards, and importantly, it proposes to extend this even to non-sales activity, such as financial incentives arising from sub-accounting or administrative services. Well, what must you do to address these? Well, if it is a financial incentive, it must be either mitigated or eliminated. Now, if it's not related to a financial incentive, the Commission has said the broker-dealer can exercise its judgment as to what is the best way to deal with the conflict, disclosing it, mitigating it, eliminating it. But once it's a financial incentive, it has to be either mitigated or eliminated. In general terms, the Commission is proposing a principles-based approach here, and it has suggested various things that would constitute mitigation. For example, heightened supervision in targeted areas, like near thresholds for firm recognition, which seems a fairly practical approach. Establishing neutral compensation factors, eliminating variable compensation within comparable product lines, and issues like that. The Commission has said all of those would be mitigation. What does elimination mean? Well, elimination means you just don't recommend products that carry with them significant financial incentives and conflicts. For example, the Commission pointed at sales contests, saying a sales contest would be something that could be eliminated to simply avoid the conflict of interest. Bottom line, though, as you look at this and the conflict of interest regulation that it's introducing, the concept is to take your existing requirements and dial them up. Well, let's go to the next slide, please. And I'm going to spend only a few seconds on this. The Form CRS, even though I think I would like to note that this is one of the pieces of the rulemaking that seems to be generating a lot of discussion as to its value and how it will work. And the reason I'm not going to spend a lot of time on it is it's laid out all pretty clearly in the rule proposal as to what the Commission is trying to do. I think there are a couple points here that I'd like to make that are a little interesting. One is, throughout the best interest rulemaking, the Commission repeatedly describes this as high-level disclosures, and this having simply a place in a layered disclosure approach. So as one looks at Regulation CRS with its required disclosures and proposed required language, the Commission really sees this as a starting point, not something that is an end in itself other than to help resolve the confusion between broker-dealers and investment advisors. And if I were to point to anything on Form CRS is raising an interesting question that people have to work through. The definition for retail investor is different here. Under Form CRS, it's any natural person, meaning individual investors of great wealth and sophistication will become retail investors under the form, which can lead to some interesting consequences. But I think the Form CRS is an interesting part of the rule, but my prediction is it's the disclosure embedded within the best interest standard itself that's going to pose a lot more interest in the comment period going forward. And with that, I'd like to hand it off now to Michael Koffler. And Michael, I believe you're going to talk about how the reform measures impact investment advisors.
And thanks, John. And before Michael goes, just a very quick housekeeping note. For those of you who would like to receive CLE credit for today's webcast, the confirmation code is Fiduciary. So please use the code Fiduciary for the sign-in sheet available for download from your viewing console.
Thanks, Cliff. Thanks, John. So first, I'm going to talk about another aspect of the rule package, which is what folks are referring to as the title proposal, which for broker-dealers, for firms that are registered solely as broker-dealers and their associated persons, the rule, there's a proposed new rule that would prohibit such firms and their associated persons from using the term advisor or advisor as part of their titles or in communications with the public, such as business cards, letterhead, web pages, etc. A couple of interesting aspects of this. One is, even during the commission hearing, there was a recognition by the commissioners that we're just focusing on a single word spelled in two different ways, but there were other words that create similar confusion as to the capacity in which an investment professional is acting. Commissioner Stein referred to this as a whack-the-mole problem. And so other terms such as wealth manager would not be prohibited, even though the word manage in wealth manager connotes arguably something even more, a role of management that even the word advisor does not connote. Nonetheless, the commission in the release says the real purpose of prohibiting the word advisor or advisor is not so much to eliminate confusion among customers about the capacity one is acting, but really we don't want broker-dealers that are just broker-dealers to call themselves advisor in any way. And you can ask the question, does that make sense? Did the commission do enough here? But they really said our focus here is really just on eliminating broker-dealers and only broker-dealers from calling themselves advisors. And they also pointed out that the form that John was just talking about, CRS, the real primary purpose of that form is to make clear the capacity in which one is acting. And in addition, regulation best interest, one of the disclosures that is required by that is a disclosure about the capacity in which the financial professional is acting. So they're looking to these other requirements to deal with the broader confusion issue, and they're really just focusing on the word advisor in this particular proposal. With respect to dual registrants, such firms and their personnel would be able to use the term advisor or advisor, but with respect to the individuals, only if the person is a supervised person of the investment advisor and is himself or herself actually involved in providing advice on behalf of the investment advisor. So that means not everybody who's associated person of a dual registrant can use the word advisor or advisor. You have to be someone who's actually a supervised person of the advisor and who, as part of their job functions, is actually responsible for providing advice on behalf of the advisor. And then you could use this terminology. Turning now to the last piece of the proposed package here, as Cliff mentioned at the top of the discussion, there's a proposed interpretive release that would apply to investment advisors. And this release really, as the Commission said at the hearing and in the release, this is really meant to reaffirm and clarify the fiduciary duty that an investment advisor owes to its clients. There's, I would say 85–90%, maybe even a little more, of what's in the proposal is stuff that we've seen over the last 50 years in different places, whether it be releases, no action letters, enforcement cases, etc. But you have in one place some general principles that the Commission lays out. And again, most of it's very familiar in terms of the obligation for advisors to serve the best interests of its clients. The Commission notes that the advisor and the client can shape the relationship and through contract and may impact the roles and responsibilities, but it's still a fiduciary duty, one that the advisor cannot disclose or negotiate away, and that the investor cannot waive. Most of the release talks about the two primary duties that advisors have, the duty of care and duty of loyalty. With respect to the duty of care, there's a lot in this release that is basically taken from Release 1406 from 1994 when the Commission proposed a suitability rule for investment advisors, and there's an obligation for advisors to make a reasonable inquiry into the client's financial situation before providing advice, and then as appropriate thereafter to make a reasonable inquiry into the client's profile The nature and extent of the inquiry would depend on what's reasonable under the circumstances, as would the frequency in which they have to update the client's investment profile. One of the things the release reiterates, just like Release 1406, is that best interest for advisors is to be evaluated in the context of the client's overall portfolio, not on the basis of any particular security that is recommended or purchased for the client, but rather looking at the portfolio overall, comparing that portfolio overall to the client's investment profile. The release also notes that cost is one of many important factors. It's not necessarily the most important factor. An advisor does not have to recommend the cheapest security, and buying the cheapest security would not necessarily satisfy the advisor's duty of care. There's also an obligation to make a reasonable investigation into the investment. The release also notes that advisors' obligation to provide advice that's in the best interest of clients applies not just to the purchase and sale of securities, but all advice they provide, such as what sub-advisor to hire, or what investment strategy to utilize, etc. The second component of duties that the release talks about is the duty of best execution. I'm not going to say much here because it's, again, just repetitive of what the Commission has said in the past. And the final thing is two things: the duty to provide advice and to monitor that advice over the course of the relationship, but that the frequency can be impacted by the terms of the contract that are entered into between the client and the advisor. So that could really shape and impact the duty to monitor. But that duty to monitor, again, provides to all the advice the advisor provides. That can include, among other things, the recommendation to that a client participate in a wrap account, for instance. The other big piece of this is the duty of loyalty, which again takes from different releases and letters from the staff and the Commission over the years. You see a lot of familiar language. You have to put the client's interest first, can't favor your own interest over the client's interest, have to make full and fair disclosure of all material facts concerning the advisory relationship, which really comes out of Form ADV. The real change here is the emphasis that the Commission puts on the importance of having sufficiently specific disclosure. And there's a statement in there which is getting a lot of attention, probably more attention than any other statement, is a sentence where the Commission says, disclosure of a conflict alone is not always sufficient to satisfy the advisor's duty of loyalty in Section 206 of the Advisors Act. And what the Commission seems to be saying is there are times when the disclosure is not going to be clear enough or detailed enough to allow a client to make a reasonably informed decision. And in situations where the client, it appears from the facts at hand that the client doesn't understand the nature and import of the conflict, or if the conflict could not be fully and fairly disclosed, in those situations, disclosure alone is going to be insufficient. And the Commission says we would expect an advisor to eliminate the conflict or to adequately mitigate the conflict so that it can be more readily disclosed. So there are two threshold questions that the guidance really raises for advisors with respect to the duty of loyalty. Do they have a situation where a conflict cannot be fully and fairly disclosed because of its complexity, for instance? And if so, if the answer to the first question is yes, how do they know if they've adequately mitigated the conflict so that it can be disclosed, if they're not going to eliminate it? So those are going to be two interpretive questions that advisors face under the proposal. On the next slide, as Cliff mentioned at the beginning, one of the things that the Commission did here was not just propose the interpretive release, but basically ask, should we propose additional regulatory requirements on advisors to basically have harmonization with respect to the regulation of broker-dealers. The Commission noted there are certain areas, certain regulatory requirements that broker-dealers face that advisors do not currently face, and the Commission, while it did not formally propose these, it's asking for a comment on whether it should propose additional requirements in three areas. One is licensing and continuing education. There is no, as the Commission noted, there is no federal licensing standard today. Most states do impose registration requirements on investment advisor representatives, which it's important to note for SEC-registered advisors is defined by SEC rule, not by state law. But if an individual comes within the definition of investment advisor representative as defined by SEC rule, then the states can impose licensing, qualification, and registration obligations on these individuals who have a place of business in the state. The Commission notes that the 913 study by the staff did recommend that the Commission consider requiring IRs to be subject to a federal continuing education licensing requirement, and the Commission is requesting comment on whether it should impose that. And it asks, if so, who should be the right people that should be subject to such a requirement? Should it rely on the definition of IR? Should it rely on the definition of supervised person? Should it be individuals for whom an ADV Part 2B supplement is required? Should it be some other group of individuals? And if it does proceed, what kind of requirements in terms of continuing education should be required? What types of training, et cetera. The second idea that the Commission threw out is relates to the provision of account statements. And this really seems to be about having more transparency on fees and costs for clients to understand. And the idea is if all advisors were required to deliver periodic account statements that specify the dollar amounts of fees and expenses, then clients' understanding of their fees and expenses they pay would really improve. It did note that advisors subject to the custody rule that have legal custody, as that's defined in Rule 20642, have an obligation to make sure that they have a reasonable basis for believing that the custodian sends an account statement. In addition, advisors that are relying on the safe harbor in 3A4 under the Rule 3A4 adopted under the Investment Company Act, the sponsor has to provide client statements at least quarterly, but it noted not all advisors have legal custody or are relying on the safe harbor, and so there's a gap here, and they're asking is the gap big enough that they should fill that gap. And the third area is financial responsibility requirements. The Commission noted that advisors are not subject to a federal net capital obligation. Certain states have adopted net capital rules for advisors, but there's no federal requirement. And this idea really stems from the Commission's observation that there are times when it comes across a serious fraud that's been committed by advisors, and because these are capital light entities very often the assets of the advisor are not sufficient to compensate clients for the fraud that they have experienced. And so the net capital requirement it seems to be primarily designed to satisfy that problem that's been identified by the Commission. The Commission alternatively notes maybe we could deal with this problem through a fidelity bond. And it asks, which one is better, and if we require net capital, how much net capital should be required? If we require a fidelity bond, what should be the minimal amount of the bond? And then the third idea they put out is, should we require advisors to be subject to an annual audit requirement as broker-dealers are today? So again, these are not proposed in the release, but their Commission is requesting comments on whether it should propose these obligations in the future. So I'm going to turn it over to Carol, who is going to be talking about considerations in the retirement space. Carol?
Thank you, Michael. If your responsibility is in the retirement space, there are three questions at this particular moment in time to think about. First, what exactly are the DOL rules that are operating at this point? They have been in a state of flux since 2010, as we mentioned, when the first fiduciary reproposal was made, and they're still in a state of flux. We have the fiduciary rule, as you all know, has been vacated. I was hoping that I would be able to tell you that the official mandate getting rid of it had been issued. It was expected yesterday. As of 12/31 this afternoon, it has not yet been issued, but it will be. So the next step would be, there's one last hurrah left, and that would be if the DOL asks the Supreme Court to review, and we do not expect that to happen. So the next point would be whether the DOL concurs with the prevailing view that the effect of the vacature would be that the prior law, which was a five-part test that we'll get into in a little bit, is what is in effect. And the third kind of state of flux that we have is whether the new DOL administration will make changes to existing law. And some things that we do know is that even though the DOL fiduciary rule as we know it is gone, there are parts of ERISA and Section 4975 of the code that apply even to people who are not fiduciaries. For example, one question that just came in to the panel was how the requirements for ERISA bonds might be affected by the change. ERISA bonding requirements apply beyond fiduciaries to any party who is holding planned funds. That was in effect before the rule, and that will continue after the rule. So that's one example. Second, what's on everyone's minds is how the SEC proposal itself will operate in this space. In particular, there are questions being discussed about who are retail investors and who are retail customers. It certainly looks like IRA owners and possibly plan participants would fall into those categories. And then there may be even plan sponsors. The preamble to the release states that trustees for natural persons are retail investors, and retirement plans in the ERISA space are generally run by trustees. So, there may be some non-natural person entities that get, brought into this as well. And third, what is the interplay between the SEC and the DOL IRS rules? There have always been at least two sets of regulatory regimes applying to the investment of retirement plans, but certainly without doubt it's become more complicated. I was taking some notes during John and Michael's presentations and just comparing how that applies to, in the ERISA world, the disclosure of conflicts, for example. We have conflict of interest, prohibited transactions in ERISA, and the disclosure of something as a material conflict is going to affect analysis and arguments that people may make that something really isn't a conflict. So that is a new challenge we're looking at. The duties of prudence and loyalty, which John and Michael talked about, they're kind of set out in the SEC proposal, but those standards are very different than what we think of in ERISA as fiduciary duties of prudence and loyalty. So if you are an ERISA fiduciary still after the DOL rule, you need to be careful about which standards of care are applicable. So at least at this point in time, it does seem to us that they're not exactly quite on point. You could be subject still to multiple standards of care. And speaking of whether you're an ERISA fiduciary, it kind of brings us to our next slide, which as I mentioned, the prevailing view was we go back to the old 5-part test. Putting aside the BIC exemption, which we were all very excited about, what the fiduciary rule really did from an ERISA point of view is it expanded the definition of an investment advice fiduciary. So the concept of the investment advice fiduciary is not something new. It's just who falls within that definition. There's always been the concept of an investment advice fiduciary. That's still there. The prohibited transactions that we were concerned about, those are still there. And so the challenge in going forward trying to comply with the new SEC proposal, if it goes final, is to comply with that without bringing yourself back into ERISA world. And for that, we'll go over quickly the 5-part fiduciary definition, because that, at least for the time being, will be what we're looking towards to see whether you're an ERISA fiduciary or not. So going through the slide, for a direct or indirect fee, and I want to emphasize indirect fee. We talked a lot about that when we were dealing with complying with the BIC exemption. What is compensation for purposes of the BIC? Well, this concept of an indirect fee or indirect compensation, that was there before the DOL rule, and so that has not been affected. So as of this point in time, at least, the DOL's broad view of what's considered a fee is still there. Part 1 of the test renders advice as to the value of securities or makes a recommendation. If you're in the regulation best interest, you're probably making a recommendation. So you can assume, factor 1 will probably be met. Number 2 is on a regular basis, and this is the most important part of the 5-part fiduciary definition. Prior to the DOL rule, this was the key that particularly broker-dealers would argue that they're not ERISA fiduciaries because they're giving a one-time piece of advice. It's not on a regular basis. So if we're back into this again, I think that is the key to look at. And as I look through some of the disclosure provisions that talk about disclosing the scope of the relationship, these are places that you want to focus on when you're doing that disclosure to make sure you're not pulling yourself into this regular basis definition. The third part is a mutual agreement, arrangement, or understanding between the plan and the fiduciary. I think mutual is good. We didn't have that in the DOL rule. But I think that, disclosure obligations, again, are going to pretty much satisfy this requirement. Number 4, the primary basis requirement. To be an ERISA fiduciary, the investment advice is intended to serve as the primary basis for the investment decisions. So again, this will be interesting how this plays out in the new SEC world, where you have disclosures and standards of conduct. All of these are going back into what could be the primary basis. So that's something to focus on going forward. And finally, the advice will be individualized based on the particular needs of the plan or the plan participant. And as I hear the duty of care described, there's a lot going into the individual needs and the individual situation of the investor. And so that seems to go into the individualized test. So assuming that the SEC proposal does go final, I think we're back to where we were before the rule, which is looking at the regular basis and the primary basis. And again, going back a little bit to what's going on with the DOL, on this slide, yesterday the DOL issued a new temporary enforcement policy, which is on this slide. And this may be confusing because it's still going into, it sounds a lot like the fiduciary rule when you read particularly the highlighted language, which mentions the impartial conduct standards. What this does is if you are an ERISA fiduciary under whatever test, the 5-part test or whatever happens going forward, what this enforcement policy does is essentially it gives you a prohibited transaction exemption if you continue to rely on the impartial conduct standards, which if you are an ERISA fiduciary, you're probably doing that anyway. But this is what the transition BIC relief was basically limited to the impartial conduct standards. A funny thing that happened by everything being vacated is in ERISA, where exemptions are generally a good idea, and we like exemptions, but the BIC itself and all of the horrible compliance issues raised by it were actually an exemption. It was actually provides you relief if you would comply with all of the different conditions. So what happens with the rule gone, including the BIC, is that if a fiduciary was relying on the transition BIC during this period of time that we had the rule in effect, they may have committed prohibited transactions without having an exemption. So basically all this enforcement policy is doing is it's giving those fiduciaries an exemption for prohibited transactions. This enforcement policy really does nothing with respect to private litigation. So, that's still out there as an issue. But, as far as, if you are a fiduciary, this enforcement policy gives you some relief. What we're still waiting for is some additional appropriate guidance that we're expecting from the DOL, and this might include some retroactive exemptions that would go back to the June 9th, 2017, when the rule went into effect, that may give some relief, as well as some additional proposals and new exemptions that might go forward. So with that, I will go back to Cliff.
Thanks, Carol. So before we get to what's next and wrapping up, just a couple of questions came in. A whole bunch of questions came in about the definition of retail customer, and I think sort of people coming into this sort of probably had the impression coming into the rulemaking or anticipating the rulemaking that the definition of customer and the suitability might be the same as regulation best interest, and any disclosure will be the same. And in fact, they're different definitions. And the SEC talks about the different definitions and why, but at the same time they ask for comment. But in terms of like the questions that were received, you heard John mention that the definition of customer in Form CRS is different than the definition in regulation best interest, and also the definition in terms of FINRA suitability. That's delivered on the SEC's part, but it might be something it will be something that gets played out in the comment process. Another question came in about, I'm going to turn over to Michael to talk about this, the fiduciary interpretation that applies to advisors. Does that have any impact in the institutional marketplace for advisors, or is that only with respect to advisory services engaged in with respect to retail clients?
Yeah, thanks, Cliff. So you can view it as a contrast to the regulation best interest that is being proposed for broker-dealers. The advice, the proposed interpretive position would apply to all advisors, just as an advisor's fiduciary duties today apply to all of its clients, whether the clients are institutional or retail. So the guidance applies to all the clients. There is no such distinction made on the advisor side.
Great, thanks. In terms of what's next, the SEC provided a healthy enough amount of time to comment, 90 days, and that period is going to begin tomorrow. The notices are anticipated to run in the Federal Register tomorrow. So again, that 90-day clock will start tomorrow, and again, we'll be seeing sort of the next phase of this whole rulemaking in terms of consumer groups, interested parties, trade groups, firms begin to prepare comment letters. So a lot of developments to come. Carol mentioned the DOL and what we anticipate there, and at the same time, we continue to expect developments on the state security side and on the state insurance end of things with respect to certain states establishing and advancing standard of care for broker-dealers. And at the same time, it's important to take note of Chairman Clayton's recent speech last week, where he very directly said it's incumbent upon all regulators, the SEC, DOL, the states, to make sure that, as a whole, the framework that established is workable and coordinated. So again, a lot more to come in terms of overall coordination. And with that, we wanted to thank everyone for joining us today. As a reminder, if you want to receive CLE credit for the webcast, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. And again, if any of you have questions or you'd like to receive a copy of the slide deck, please feel free to contact any one of us. We'd be happy to get it to you. So thanks, everyone, for joining.